video recorded as well as live streamed. So we ask counsel to please identify yourself and your client at the beginning of your argument. Chief Justice Swan, as you can tell, is appearing virtually. This is helping us to adhere to our social distancing parameters. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs. We have discussed this case in conference. We're familiar with the facts. Please take that into consideration during your presentation. At this point, counsel, are you ready?
Yes, Your Honor.
Please proceed.
Good morning, and may it please the court. My name is Robert Burke, and with my co-counsel, Mr. Callahan, we represent Commonwealth Land Title Association. My goal is to reserve a few minutes for rebuttal, and I understand that's my responsibility. The starting point is to, I think, acknowledge that there is something at least potentially suspect about the continuing judgment against Commonwealth. A single purported Morris agreement covering policies issued by both Fidelity and Commonwealth was invalidated as to Fidelity, but not as to Commonwealth. Leaving aside, and I'm sure we'll get there, whether Commonwealth is entitled to relief under Rule 60. The judgment against Commonwealth should, if Rule 60 permits, at least be examined to see if this judgment falls into any of the Rule 60B categories. Rather than repeat what's in our brief, I was trying to anticipate what questions you might have, and so I'm going to focus on those areas that I think are the areas in primary dispute. The first one is timeliness. We are seeking relief. May I turn this?
You may.
I won't get any closer to you, I promise.
And Judge Swan, I don't know if you're going to be able to see this.
And just for the record, this is just a blow up of Rule 60, which I know you already have.
We do.
But I highlighted the pertinent provisions. Obviously, and as you know, motion for relief under the first three sections has a 6-month time limit. There is no such limit to motions brought under 60B5. The only limitation is reasonableness. And the absence of a bright line test in terms of the amount of time is intentional and makes sense, given that by definition, the events which typically give rise to Rule 60 relief, like the satisfaction or reversal of a judgment, are beyond the control of the parties. They happen when they happen. And until they happen, Rule 60 relief isn't ripe. And so that's why there can't be a set time limit, because we don't know procedurally when things are going to happen. And for that reason, what constitutes a reasonable time in any particular case depends on the procedural history and posture of that case. So let's look at the dates here. Oh, I'm sorry, Your Honor.
Let me just ask you this right off the bat. Your mandate or the judgment you're seeking to be relieved from was entered what year?
The mandate was issued in October of 2017.
When was the order you're seeking to have reviewed issued by the trial court?
The middle July of 2012.
Okay. So explain to me how you get all the way to 2020 seeking to have something reversed, and how can you make the timeliness argument genuinely in this circumstance if you're seeking to overturn a 2012 order?
Well, thank you, Your Honor. And I don't think, I mean, we filed our motion in 2018. So we're now on appeal and it's 2020. The last 2 years have been as this case wound its way through the process. So I don't think the reasonableness clock should run during that time. It should run from the time we sought relief. So the first 5 years post-judgment are the time it took the mandate to issue.
But your client wasn't party to that litigation.
Right, correct. But until the mandate issued reversing the judgment as to Fidelity, there was no Rule 60B5 basis for Commonwealth to seek relief. The predicate for Commonwealth's motion was that the judgment against Fidelity was vacated. So really, in terms of that timeline Your Honor discussed, the first 5 years of it, the motion for relief wasn't ripe. They couldn't have filed before then because they didn't have the reversal upon which the motion is based.
Counsel?
Yes.
Yeah. If I'm not mistaken, there was motion practice in the Court of Appeals either during or before 2015 concerning Commonwealth's participation in the appeal, correct?
Yes, Your Honor.
And that motion practice was resolved in a manner adverse to Commonwealth.
That is correct.
And that happened in 2015 or 2014?
I think it was 2015 that the motion to dismiss and the motions for reconsideration from that resolved.
Okay, and when that happened, unless those orders were simply a nullity whose effects were so unpredictable that a mandate was required, it seems to me that Commonwealth was on notice that its rights might be in jeopardy as far back as 5 years ago. Am I mistaken?
With all due respect, I think you are, Your Honor, because until the predicate for this motion is that the judgment was vacated as to Fidelity. Yes, Commonwealth knew that it was not going to be part of the appeal before the mandate was issued, but until the mandate was issued, the predicate didn't exist. This motion depends upon the vacation of the judgment, which didn't happen until 2017. If Commonwealth had sought, I'm sorry, Your Honor, go ahead.
But what was Commonwealth's upside? At the moment the motion to dismiss was resolved, Commonwealth had no hope of appellate relief. Is that not correct?
That is correct, although at that point, until the mandate issued, we don't know the result as to Fidelity. For example, before the mandate issued, it was possible that the judgment would be not released or not vacated as to Fidelity. If that were the case,
the judgment could have been affirmed, and then all of this would be sort of much ado about nothing. But as early as 2015, Commonwealth knew that if there were a prospect of reversal, it had to be in it to win it, right? It couldn't just sit by as a non-party and hope for a good result.
Again,
so,
sorry, go ahead.
Whatever the result was, wasn't it Commonwealth's responsibility to make sure that it postured itself to take advantage of any vacation of the judgment?
I don't think so, Your Honor. And the reason is the mere possibility that there might in the future be a basis for Rule 65 relief, that can't start the clock running in terms of reasonableness. Until Fidelity is out, because the judgment is vacated as to Fidelity, Commonwealth doesn't know if it has a basis for relief or not. Yes, Your Honor is correct. They were aware of the possibility that by the time the mandate issued, the judgment would not exist as to Fidelity, but they didn't predict the future. And until we knew there was a basis, frankly, if we had filed that motion then, it would have been premature. It would have been there would have been no real controversy, because why would Commonwealth get relief when we didn't know if that relief would matter? If the judgment was affirmed as to Fidelity, Commonwealth's presence or absence from the appeal would be irrelevant.
So let's go back to, if we were to accept what you just said, the 2015 isn't the time
Right.
when it, okay. Let's talk about the mandate was issued, and it took a year after the mandate was issued before your client filed for relief under Rule 60. Explain why that shouldn't be the time frame, and why that is reasonable to delay a year.
Okay, and it's exactly where I was going to go, and I appreciate the question, because I think it is the sort of the elephant in the room. And I don't think there's a whole lot of quibbling in the briefs about that period up until the mandate issued, but I think the focus is on what happened in the year preceding the motion. Again, you got to look at the specific procedural posture of the case. So the parties are in the companion coverage case before Judge Whitten. And now we have the decision in Centerpoint, this court's decision in Centerpoint. And the question, the $1 million question is, or the $50 million question is, what does it mean? How does it affect those claims, the bad faith and coverage claims against both Fidelity and Commonwealth? Commonwealth took the position before Judge Whitten that the invalidation of the agreement as to Fidelity meant, as a matter of law, that the insureds had breached the cooperation clause, and that the legal result of that was that they forfeited all claims against Fidelity. CMLC didn't sign off on that. CMLC took the exact opposite position. Their position was, it doesn't matter. That ruling in Centerpoint actually has no effect on the claims in the coverage case. So until that issue is resolved, we're again in the situation where Commonwealth, had it filed its motion, would have been seeking speculative relief. Because let's assume Judge Whitten had agreed with CMLC and said, I don't think it matters. I don't think Centerpoint affects the right of Fidelity to pursue these bad faith and coverage claims. Then Commonwealth doesn't need relief because its absence from the appeal is irrelevant. It would be in the same position whether or not it filed a Rule 60 motion. What happened, so the parties in 2018 litigated that issue before Judge Whitten. And it wasn't until August of 2018 that he decided it. And that's when I think the reasonableness clock reasonably begins to run. Because at that point, what Judge Whitten said is, yes, Fidelity, you're out. They forfeited all claims against you. But Commonwealth, you weren't a party to the appeal. I can't grant you that relief. Until that happened, there was no reason for Commonwealth to seek relief. It may not have mattered. Again, had Judge Whitten agreed with CMLC, there would be no reason for Commonwealth to seek relief because its presence or absence from the appeal wouldn't change its rights or defenses. So
it took you another 2 months to get it filed after that was issued by the trial court.
yes.
So in your estimation, or if we accept what you say is true, we have to decide whether or not 2 months is reasonable, and that's what you're telling us.
That's exactly right. The reasonableness clock, again, you have to look at each case to see when it logically starts to run. It starts to run here when it became apparent from Judge Whitten's rulings that Fidelity's absence from the appeal and the continuing existence of the judgment, that Commonwealth's absence and the continuing judgment against Commonwealth mattered. And yes, the two month delay is in Commonwealth's opinion what we should be talking about. Is that reasonable? And we would just submit that's not unprecedented. There are cases, and Judge Kiley relied upon one that said 5 weeks is too long. There's no bright line there, but it's that 2 months. That's the reasonableness time we should be talking about.
So if we all go back to when the judgment was entered, we're talking about 2012. In an abundance of caution, you could have filed a Rule 60 motion as a placeholder and had the court say, this is premature. Let us, and it would have put the opponents on notice that you're coming after and challenging this judgment. Why didn't you?
I don't know. I mean, candidly, I don't know that occurred to anyone, nor do I think that there's any requirement that you file a placeholder motion. But
I'm not saying there's a requirement
Right.
you file a placeholder motion, but if you're seeking to overturn a judgment and you know in the future it's tangential over here, I want to make sure this is done timely, and we look at your Rule 60, and 6 months is timely, and within a reasonable period of time is timely. Why shouldn't we be looking at the 2012 entry of judgment to make a determination about whether it's reasonable?
had we filed in 2013, what would have been the basis of that motion, Your Honor? There hadn't been a vacation of the judgment as against, but there would be no basis for Rule 60 relief. It was not until the mandate issued that we even had a colorable Rule 60 motion. So this idea that we would have filed something preemptively, and facetiously, but, Your Honors, we filed a motion before Judge Burke or Kiley saying there may in the future be a basis for Rule 60b-5 relief, and we want to preserve that. I don't know that that's a reasonable thing to do. Again, the standard is reasonableness. Commonwealth waited appropriately until it mattered. We weren't seeking an advisory opinion. We didn't want to file a placeholder. When it became clear from Judge Whitten that Fidelity got relief that was denied to Commonwealth, at that moment, the Rule 60b-5 issue crystallized. And yes, we waited 2 months after that to file, and if Your Honors find that 2 months is an unreasonable delay, given the complexity and procedural history of this case, that's certainly within your discretion. I don't think that's an appropriate limitation. And as to Your Honor's question about, I'm sorry, Judge?
Finish your answer to Judge Campbell's question. I'm sorry.
Thank you, Judge Blunt. As to Your Honor's question about shouldn't we have put them on notice, they were on notice. The issue, as Your Honor noted earlier, the issue of whether it was appropriate to bind Commonwealth to this purported Morris agreement never went away. Even after the appeal, again, we sought that relief from Judge Whitten. He said, I don't have jurisdiction. The presence or absence of a Rule 60 motion, it wasn't about putting them on notice. They knew from the day Commonwealth was dismissed from the appeal, that Commonwealth believed it was entitled to relief. It didn't have a basis for relief until much later. But there were proceedings before the Supreme Court where Commonwealth said, hey, we know we're not a party, but we should get the benefit. And the court said no jurisdiction. So that was the limitation. And the only way to fix jurisdiction, it turned out, was to go back to Judge Kiley. Other courts simply couldn't do, and Judge Whitten essentially said, my hands are tied. I can't fix this because the judgment's still there. Okay, what's the next procedural step? Let's fix the judgment. And with that, Judge Swan, did you have another question? I'm sorry.
Well, I do. I just want to, you've focused a lot on the issuance of the mandate, and from a certain technical standpoint, you're correct that the mandate is what makes a decision effective. But in 2015, the Court of Appeals gave the parties more than a fair idea of what the outcome of the appellate process would be. The odds of that 2015 opinion changing before the mandate really depended on the Supreme Court taking the case and reversing the Court of Appeals, which statistically is, happens fairly rarely. So how can you say that in 2015 you didn't have a colorable argument?
Because
of what the Court of Appeals had done.
Because, again, the decision wasn't final. Yes, the opinion, the initial opinion was issued. That was followed by months and months of motions for reconsideration by both sides and a petition to the Supreme Court. I guess, candidly, Your Honor, yes, we could have said all that procedural wrangling is unlikely to change the result, and so we're going to file a preemptive or prospective motion under Rule 60. That, I guess, was an option, but we thought the proper course of action, Commonwealth thought the proper course of action was to wait till we actually had a basis. And it mattered. And the basis didn't occur until the mandate issued, and it didn't matter until Judge Whitten said it matters. Up until that point, we didn't know if Commonwealth needed relief. It might not have mattered. I only have a couple minutes left. There's a lot to cover, but do you have any more questions of me before I reserve my time for rebuttal?
Judge Swan?
No.
Judge Winthrop?
No. Thank you, Your Honor.
Thank you. Counsel?
Thank you, Your Honor. My name is Richard Lorenzen, and I represent Centerpoint Mechanic Lien Claims, LLC. And with me are Keith Hendricks and Will Fishback, who represent the co-appellees. And I'll be doing the argument today. If there's any time left at the end, they're certainly welcome to provide any comments, but that's our game plan.
Wonderful. Thank you.
Obviously, we're talking a lot about timeliness, and that's critical to this entire appeal. And I just want to frame that a little bit because one of the things that kept ringing through to me when I was preparing for the hearing is that it's impossible to overemphasize the importance of our public policy in favor of the finality of judgments in this context. That's really the principle that orders our entire civil litigation procedure that enables parties to get something from the time and expense put into litigation that enables them to have certainty as to their affairs. And Rule 60 upholds that principle of finality in every subpart of the rule very carefully. And that's why when you look at for B5 and B6, for example, they're carefully designed to provide a party with relief from the finality of a judgment only under very specific circumstances where there's been a significant change in circumstances and the party who's aggrieved is not responsible for the finality of the judgment against it. B5 is a perfect example. The judge had no choice but to enter a judgment against this party because of the preclusive effect of a prior judgment. The prior or earlier judgment is subsequently reversed. Well, okay, that makes sense. That's not what happened here. And the party had no control over that. As to B6, leaving aside for the moment, although I'll come back to it, B6 can't be used as a substitute for B1 to get relief for a mistake, which is all that we have here. So,
Mr. Lorenzen, let me just
Sure.
ask you a quick question. If, let's say, you were on, at what point do you think they should have filed this? When would it have been timely?
Well, the thing, in order for me to answer that, I have to break it down. And the first answer is because their real basis for seeking relief is that they made the decision not to file a notice of appeal. They should have filed within 6 months of the entry of the judgment in June 2012. Those are the real grounds. Commonwealth says, they call it a mistake, but it's a conscious decision not to file a notice of appeal. They said, we want to appeal, but we're not going to do so because we think we're already covered by Fidelity's appeal. That's a very strange position. We have to take it as it comes. But Commonwealth is a large insurance company. It's involved in litigation all over the country all the time. It was represented by counsel, both in the underlying litigation and on appeal. And yet it says it made a decision not to file a notice of appeal because it determined it was already covered by its sister company's notice. Well, that's fine. It's a free country. I mean, parties are allowed to do what they want, but they bear the consequences of it. Now, when you shift to when was there a basis for seeking relief under B5 or B6, we would argue, first of all, that you can't use B5 and B6 as substitutes for B1. They're mutually exclusive. If you take that off the table, then the history, and you all appear to be, I'm sorry, let me back up one point. This is very important. I mean, the standard of review on the timeliness and on the court's order is abuse of discretion. And counsel even said there's no bright line and it could have gone the other way. That's not abuse of discretion. But in terms of when there was a B5 or B6 argument, as Judge Swan pointed out, there was motion practice in the Centerpoint appeal. And there was some of it in 2014, which was Commonwealth trying to appeal and being rejected. Then, in August of 2015, the Court of Appeals issued its ruling that said, we're vacating the judgment as to Fidelity, but the judgment remains in effect as to Commonwealth. Now, Commonwealth could have said at that point, well, the Fidelity, as it argues here, the Fidelity judgment was a preclusive judgment that required the court to enter judgment against Commonwealth, which is not correct. But that's the B5 argument. That came up right there. And Commonwealth didn't make that argument. It didn't seek relief. It filed a motion for reconsideration in the Court of Appeals, and it said, court, you have jurisdiction to extend your holding in favor of Fidelity to Commonwealth under the estate of Friedman case and similar cases that they cite on page 22 of their reply. And they asked the court to do that. And the Court of Appeals said no. And the Court of Appeals further clarified its original opinion to reflect that the judgment that remains in effect against Commonwealth is the one that was actually entered by the trial court, not a proposed stipulated judgment that it had referred to in its original opinion. So Commonwealth took no action, had a basis for making its arguments. It could, and I want to pause there because the core of its argument is the judgment against Commonwealth is inextricably intertwined with the judgment against Fidelity. That's their argument. What they're trying to do is twist it to make it fit within B5 or B6, but that's the argument. And that's the argument that it made to the Court of Appeals in 2015, in September. And the Court of Appeals, this is important because the Court of Appeals is the only court that's ever had jurisdiction to extend that opinion in favor of Fidelity to Commonwealth under the authority of estate of Friedman and the other cases. And what they're trying to do is conflate that previous panels, this court's jurisdiction in that previous case with what it says a trial court could have done under Rule 60. So the inextricably intertwined argument was there in 2014. They made it, and this court rejected it. They didn't take any action at that point. They then filed a motion for summary judgment in the declaratory action, claiming that that court had jurisdiction to extend the ruling in favor of Fidelity to Commonwealth because it's inextricably intertwined. Same argument. Judge Witten said, no, I can't do that. It's a final judgment. That's July of 2017. And counsel said that when Judge Witten said he was bound by the judgment, that was the time to take action to fix the judgment. But they didn't. That's July 2017. All of the arguments are there at that point. The only thing that was missing was them saying, well, hey, if we had appealed, or if we had previously set aside the judgment, Judge Witten it actually did agree with our interpretation of the Centerpoint. That's like saying, hey, it would have been a good idea for us to have moved promptly. That's not a basis for the relief. And so what happened in July of 2017, the court denied the motion for summary judgment, said the judgment is final. Then later that year, or early 18, Commonwealth stipulated to a scheduling order in the declaratory action that set deadlines for expert disclosures, fact disclosures, and completion of discovery, which had to be finished in June of 2018. And then we went forward and we did all of that. Spent who knows how many hours and dollars of attorney's fees. And then they waited until November of 18, which was a month before a trial scheduling conference in the declaratory action, to seek relief. And on the basis of that, they were able to postpone the trial scheduling conference, and it was further delayed.
Counsel?
Sorry.
Can I begin for a moment? I think the discussion today well illustrates that there's a lot of points along the timeline that are debatably triggering points for the filing of a motion, and you can argue that they should be later or earlier, but my question to you is a little bit different. Assuming for a moment that there was more delay than was necessary, does that matter? Is anyone prejudiced by the delay here, given all of the intermediate procedural wrangling that was going on?
Well, I thank you, Your Honor, and I think that the sorts of things I was just talking about would constitute prejudice. All of the years of work and expenses putting this together to go to trial, and now we're in a situation where, since Judge Kiley denied the Rule 60 motion, there's been a trial. We had a jury trial, and the jury found that Commonwealth was guilty of insurance bad faith and awarded $5 million. And now, are we talking about now giving Commonwealth some, and I guarantee they'd try it, take that as a basis to now try to unwind that judgment? There's just no finality at all, and I think that is prejudicial. We're entitled to proceed in accordance with the rules based on the finality of a judgment, and they're entitled to exercise their rights as well, but they're required to do so reasonably. And again, I can't, they've never demonstrated that there was no prejudice. I think there clearly is. I think it's probably a moot point now because we've gotten a judgment. And further, we would be prejudiced to the extent that this court were to indicate in some way that that they're entitled to relief, which is really what they're seeking, in the form of a reversal of the judgment. It's not setting it aside. They want this court to say, oh, well, the same rationale and ruling in the Centerpoint case applies in the same manner to Commonwealth because they're inextricably intertwined. And that, we think, is a collateral attack on this court's prior judgment and not permitted under the rule. So that would be my answer, although I've incorporated some other concepts as well.
Thank you.
And again, I think I probably just said it again. There's no basis for a finding that Judge Kiley abused his discretion in finding that it was not filed in a reasonable time. I guess just quickly, I wanted to note that in their reply, Commonwealth says that our authorities that we cite for the proposition that Rule 60B5, second clause of that rule, just deals with judgments, prior judgments that had a preclusive effect. They say that those authorities were talking about the third clause of that rule. That's not correct. They're all, I could cite them chapter and verse. They're all talking about the second clause. It has to be a prior judgment with preclusive effect. And then as to the B6 argument in their reply, we pointed out below, and Judge Kiley held in part on the basis that B6 relief requires that the aggrieved party be in a situation because of circumstances beyond its control. And they say in their reply, well, that's the federal standard, that's not the state standard, and that's incorrect as well. In Arizona, the standard for B6 is the same as the federal counterparts. And for example, in Sloan versus Farmers Insurance Company, it's a 2017 opinion from this court cited by Commonwealth. This court adopted a Ninth Circuit Court of Appeals decision to hold that a party seeking relief under Rule 60B6 must demonstrate both injury and circumstances beyond his control that prevented him from proceeding with the action in a proper fashion. That's the Arizona law. And there's no circumstances beyond Commonwealth's control that prevented it from proceeding in a proper fashion. They say, we decided not to appeal because we looked at it and we determined that we were already covered. Well, that was wrong. And the one thing that I think common thread that runs through all of the case law and the rules, subparts of 60B, is that our legal system does not turn a blind eye to the finality of judgments to rescue parties who refuse to help themselves. I have nothing further if you have no more questions.
Judge Swan? Judge Swan, do you have any other questions?
I don't. Thank you.
Thank you, Judge.
Judge Winthrop?
Thank you, Judge.
Thank you, counsel.
We have a few more minutes.
I have one comment I'd like to make. Do I need
You
to
guys
get
are
closer?
going to need to switch seats just because Judge Swan won't hear a thing if you're not speaking into a microphone.
I just want to amplify one point. It's been briefly raised, but I think it bears some expansion, and that is that the reasonableness is a determination by the trial court, not this court. This court's decision is abuse of discretion, not whether this court would reach the same determination as the trial court, but whether the trial court abused its discretion in reaching the decision that it reached. And so this is not an issue of first, you don't make the de novo determination of whether it was a reasonable delay, but whether or not the trial court abused its discretion. Even if this court were to decide that it would reach a different determination had it addressed the issue first, that is not the question before the court. And that's the only point I wanted to amplify.
Thank you, counsel. Musical chairs over here, gentlemen. Sorry.
Good morning, and I could just emphasize one point briefly. It actually is raised around page 13 or 14 of the brief submitted by Mr. Lorenzen. But my client, Universal, was an insured under the Commonwealth policies, and therefore it was fundamentally situated differently than the insureds under the Fidelity parties that this court's opinion in the Centerpoint case applied to. So in terms of going back to Judge Swan's point about who would be prejudiced, a ruling in favor of the appellant in this case would essentially be foisting upon Universal a decision issued by this case in Centerpoint that was based on facts and circumstances that are fundamentally different than Universal. And I won't go into any more details other than to say that it would require, I believe, the entire issue to be relitigated. And what the appellant is trying to do here is ask this court to not only vacate the judgment, but essentially declare a new winner. And we believe that would be not only prejudicial, but highly inappropriate under Rule 60 practice.
Thank you. Any questions, Judge Swan?
Thank you.
Thank you, counsel. Anything further, Mr. Lorenzen?
Just very briefly, following up on something Mr. Fishback said, if it were to be relevant to your analysis, I do want to make the point that this so-called Morris judgment is not the typical kind of Morris judgment. And if you look at it, it's not, as they try to just focus on, all it approved was an agreement that the Court of Appeals found was non-compliant, but that's not correct. Judge Burke said the court finds that the agreements reached by the insureds, the original mechanic lien plaintiffs, and substituted plaintiff Centerpoint Mechanic Lien Claims LLC to settle the claims in this litigation in connection with the sale of Centerpoint are of the type contemplated and covered by United Services Automobile versus Morris. There's much more to it than just this one isolated thing that they keep focusing on. So that was following up on Mr. Fishback's comments. Thank you.
Thank you, counsel. Mr. Burke.
Thank you, Your Honor. In the few minutes I have left, I'd like to talk about a few of the points that were raised. This idea of finality, clearly an important issue with regard to judgments. Nobody's disputing that. But of course, Rule 60b-5, the whole point of that rule is that not everything is final. And Rule 60b-5 tries to strike a balance between finality and justice and equity. And that's what brings us here. I think there's great language. One of the cases to which we cited the court was the Werner case from the Fourth Circuit. And there's what the court said, and I think it's why we're here. It said, we are persuaded by the reasoning in Pierce Oil that when one judgment rests upon a contemporaneous judgment, actually, let me find that. Find that quote. I know my clock is running. The court said this. Okay. And this was in our brief. Although finality is an important goal, the justice function of the court demands that it must yield in appropriate circumstances to the equities of the particular case. And here's the important language. In order that the judgment might reflect the true merits of the action. That's why we're here. This judgment no longer reflects the true merits of the action. That's why Rule 60, if judgments were final and the absence of an appeal or the denial of appeal was the end of the story, we wouldn't have Rule 60b-5. It's here for this situation. Counsel, that both of the people who spoke mentioned that, Commonwealth was in a different position. Well, that's really not, it's a distinction without a difference. Here's what this court said in the Centerpoint decision. We conclude that the settlement agreement between the insured and the entity that purchased the lien claims falls outside the parameters of Morris. Rather than representing an arm's-length settlement between lien claimants and insureds, the purported Morris agreement was between the insureds and an entity they controlled. That's what was wrong with the Morris agreement in this case. It was incestuous. It wasn't the amount of the stipulated judgment, wasn't anything else. It wasn't the unique situation of Fidelity's insureds versus Commonwealth insureds. It was, by definition, an incestuous agreement. You had common ownership on both sides. That made it less than arm's length. That's a problem. Had Commonwealth been a party to that appeal, this court, as a matter of law, can determine that Commonwealth is entitled to the same relief. All you need to do is read the Centerpoint opinion. The settlement agreement that was invalidated was no less incestuous as to Commonwealth's insureds than it was as to Fidelity's insureds. That's the problem with the agreement. Real quickly, counsel talked about 60B6. 60B6 is a catch-all. We obviously included it in our request for relief because it allows the court broad discretion to do equity. This is a 60B5 motion. We fall within 60B5. 60B5 doesn't say, and there's no case law saying if you could have filed under any other section, 60B5 is not available. We're not arguing mistake here. We're arguing that things happened subsequently, which is what Rule 60B5 is all about, that make this judgment illogical and inequitable as to Commonwealth. And lastly, this idea that, both sides cited cases about, hey, if you don't appeal, do you get the benefit of the party who did appeal? That's Werner, Lowry, Cotto, both sides cited cases. Here's the problem with their analysis. The cases they cited, and we noted this in our brief, all involve decisions where somebody chose not to appeal strategically. And that makes sense. If you sit on the sidelines, Ackerman, and I don't know if I have time, I have a minute. In Ackerman,
Actually,
oh, don't I?
that's their minute.
Oh, I am out of time.
Bob's that way.
Oh, can I have your minute? No, sorry.
Wrap it up.
Okay, in Ackerman's a perfect case. End of World War II, 3 denaturalization judgments, and one of them appeals. And Mr. and Mrs. Ackerman decide, hey, we'll wait till the war is over, and this will all go away. And then when the other appeal was granted, they said, hey, we should get the same benefit. The court said no. Thinking you're covered by someone else's appeal, which is what Commonwealth did, is not the same as making a conscious, strategic decision not to appeal. We don't fall into that category of cases. Thank you, Your Honor.
Thank you. Thank you, gentlemen. I know we took a smidge of time. Would you like a smidge to just summarize or one last bite at the apple?
It's hard to resist, Your Honor, but I'll take it. In Ackerman, the movement didn't appeal because he was told by his attorney that he didn't have enough money to do so. And as the court pointed out in Ackerman, that was probably wrong. So it was a mistake based on his attorney's advice. And the court said his choice was a risk, but calculated and deliberate, and such as follows a free choice. Petitioner cannot be relieved of such a choice because hindsight seems to indicate to him that his decision not to appeal was probably wrong. Same here, and I would agree. Read the Centerpoint opinion. It says the judgment remains in effect against Commonwealth.
We have.
Thank you.
All right, counsel, we will take this matter under advisement. We will issue a written ruling in due course. We thank you for your time. Please
Thank
be
you.
safe.